LTCCC is a nonprofit, nonpartisan organization dedicated to improving care and quality of life for the elderly and adult disabled in long-term care settings. We do this through policy research and analysis, systems advocacy, public education, and we are also lucky to be the home to 2 local ombudsman programs in Northern New York. So today's webinar is entitled, "What's Wrong with Long-Term Care Facilities and What Can You and I and Residents Do About It?" And we have Eric Carlson today from Justice and Aging. Just a little bit about him before I hand it over. Eric has devoted his legal career to advocating for older Americans who need long-term care services and supports. Prior to being with Justice and Aging, he provided direct legal representation to long-term care or long-term services and supports consumers for 10 years. And he is the author of Justice and Aging's widely used guide to nursing facility advocacy, 25 common nursing home problems and how to resolve them. And that is available on our website already. It'll be available on the post-webinar page today. So without further ado for me, I'm going to stop sharing and then hand it over to Eric to get us started. Thanks, Eric.
Thanks very much, Haley. Thanks to you, to Richard, for the invitation to speak today. I'm from Justice and Aging. We're a national nonprofit. We focus on using the law to protect and to better the lives of older Americans. We, of course, have a particular focus on healthcare, but also income issues, housing, equity concerns, a broad array of concerns. On the Medicaid side, on the healthcare side, as I mentioned, we have a particular focus on folks of limited resources. So that means a specialty in all the various Medicaid programs, eligibility standards, and also the services that are covered under Medicaid. So today's presentation, it's a little bit different from what I ordinarily do. I had an invitation, a relatively open invitation to speak. So I've put together something that's a little bit different than the more, I don't know, narrow education. I don't say that in a negative sense at all that I ordinarily do. It's a little bit more thinking out loud about some broader implications in long-term care, some of the cultural things I've observed over the years. How do these discussions feel in facilities themselves and also in public policy arenas, and what explains that? So first talk about nursing facilities, then about assisted living, some thoughts on why is progress so slow. I've been doing this for a long time, and I'm not saying that we haven't made progress, but there's still a lot of bad things that were true several decades ago that are still true now. And then some thoughts on what's missing from a power dynamic perspective, from an advocacy perspective, what accounts for some of the difficulties that you see in the long-term care arena that you maybe don't see in some other areas. And, mention all this is tough. I'm a legal aid attorney, and, I could talk to any legal aid attorney and they would report that it's uphill sledding in landlord-tenant work, for example, or public benefits work, or bankruptcy work, or whatever, consumer law, whatever area that they work in, which is true. But I would submit that there's something unique about long-term care facility advocacy that deserves some thought. So starting with nursing facilities, let's think about the law. At first, you start with the state licensure standards that facility has to be licensed. And in general, there's been less activity in this area in recent years. A lot of the licensing provisions haven't been examined much over the last 10, 20, 30 years. And the reason that is that all the energy has been gone and has been put into the federal nursing facility law. And the federal nursing facility law has a broad swath because federal reimbursement is so critical in the nursing facility space. The federal law applies to any facility that accepts Medicare and or Medicaid. And that is really just about every facility. There's a very, very narrow slice, just a percentage or two probably, that can afford to accept neither Medicare nor Medicaid. But those are only the facilities that cater to a really wealthy clientele that, you know, Medicare, Medicaid, between the two of them, that constitutes more than 3/4 of the overall reimbursement for nursing facilities in the country. So there's very few facilities that can completely turn their back on all those residents. So the federal law just stretches extremely widely, and like I said, that's the reason that the state licensure standards have gotten less attention. That a lot of the quality of care advocacy and enforcement and whatnot is done at the federal level. And that's done through, as I mentioned, the federal law passed in 1990. Then that's implemented by federal regulations. Most of those were finalized in the 1990s, but not all of them. There's been action, most recently and most prominently, the federal minimum staffing standards. So there's some continuing regulation on the administrative front, and there's also periodic guidance and all sorts of changes to care compare and to the enforcement processes and all sorts of things that happen over the course of a year. The enforcement is done by inspectors. These are state surveyors, generally working for the state health department, for example, that are implementing the federal law. The federal law requires that the surveys be done on an average annually. It's supposed to be within a range of 9 to 15 months, but on an average of 12 months. Note that Justice and Aging recently filed a lawsuit against the state of Maryland for tardy surveying, that the state is far out of compliance in meeting that average of survey once every year. It is also far behind in responding to complaints. So, and it's not like Maryland is the only state that's out of compliance. There's a good number of states that have similar problems in timely performing the surveys and also the complaint investigations that they're required to do. So you've got these surveys on an average of at least annually, and then complaint investigations as well. When a violation is found, a facility is required to do a plan of correction at a minimum, and in some cases, there's fines or other sanctions assessed. It's in a minority of cases, and advocates generally have some criticism over the relatively limited number of times in which there's a sanction assessed, because otherwise the penalty, if you want to call it that, is insignificant. It's just a purported plan of correction, and the plan of correction may not be very, very, very meaningful. Let's look in the Wayback Machine here for a second. I have been doing this since 91, really. And the first experience, so I was hired to run not long out of law school at all, and I was hired to run a nursing home advocacy project, and didn't know anything about long-term care facilities at the time, but nobody else knew anything either. And the federal law had just become effective in October of 1990. And I can recall getting a call from a woman. Her husband was in a nursing facility in the San Fernando Valley, just outside of Los Angeles. And she had been told by the facility that her husband had to leave within 24 hours because his Medicare has ended and he was in a Medicare bed. They just presented that to her as well. You've got no choice here. You got to go right away. It's a Medicare bed. Sorry about that. It's Medicare rules. There's nothing we can do. And she called me up. I was really new. I looked at the law and it just didn't make any sense. There's these eviction protections, and I couldn't understand how you could force somebody out in 24 hours when you're supposed to give 30 days notice. But here this national chain was doing exactly that. And so I was unsure of myself, but I appealed it. I spoke to the nursing facility. I talked to their regional council, and they immediately capitulated and apologized and said it was a mistake, and et cetera, et cetera. But what I learned from that was to trust the law, and not to be intimidated by the confident behavior of nursing facility administrators and lawyers and directors of nurses and whatnot. They would be completely confident in a lot of these practices that appeared to be just obviously violative of the applicable law. And the more I did this, the more I learned to trust the law, to trust my own reading of that, and to not put too much stock into what I was hearing in some. And I'm not saying that all facility, right? But I'm saying in some cases, obviously there's facility people that play it straight as well, but there's a good number that don't. And I learned in those situations to question that and trust my own judgment, and gradually understood that there were a good number of these things, like the Medicare bed policy, that were just routinely implemented by nursing facilities. That's what they did, and they did it routinely, and everyone in the facility just understood that as standard operating practice. Now, as a lawyer, I could learn and push back and contest it. But it's a lot more difficult for a resident to do that, or a resident's family member to do that. Faced with those same, they're not lawyers, they can't look up the law. They don't have those resources, and they're feeling the pressure of living in the facility and getting this pushback from facility staff 7 days a week. So for reasons that I can understand, they'll often give up. They shrug their shoulders and say, "Oh, it doesn't seem right, but what can I do?" So in response to that, what I started doing was to develop some education that specifically called those things out, that it pointed it out and said, you will hear this from the long-term care facility, and it will not be true. 10 lies, 15 falsehoods, 20 myths, whatever. The title changed a little bit depending on the audience and how much time I had, but the philosophy is the same. If you're going to push back against these things, you really got to call them out. And because otherwise, if you're a little ambivalent about it, or if you don't lay it out really cleanly, for reasons that I can understand, residents and family members will give up. They're unsure of themselves. And again, I'm not blaming them. I understand their predicament. Unless you really lay it out for them, they're under a lot of pressure and may not carry through. So now, Haley referenced this guide. It's the various presentations about myths and lies and falsehoods have been organized into the guide that talks about 25 common problems, set up the same way that the presentations that I did over the years. There's this calling out the statement from the nursing facility. The nursing facility will say X. X is wrong. Here's the law says the opposite, and this is what you need to do to get what you're entitled to. So just some quick example. I'll give two of those as examples here today. One is the same Medicare bed thing, right, from 33 years ago, still going on. The facility says, well, Medicare payment is ended, so you have to leave. This is a Medicare bed. That is not true. That a Medicare bed is not, doesn't mean it's limited to Medicare reimbursed residents. It means you can access Medicare from that bed or that room, but it doesn't mean it's limited to that. And so you can pay privately from that room. And in most cases, you can bill Medicaid from that room as well. There's a little bit of complications from some states that allow distinct part Medicaid certification. But in general, the rule is, Medicare certification doesn't mean it's exclusive to Medicare. It just means you can use Medicare from that particular room. And then also note this provision, this is the second bullet point here, this provision of the nursing home reform law that specifically says that a resident can refuse a transfer within the facility, not even saying anything about going out of the facility, but even can refuse a transfer within a facility if the purpose is to move the resident out of a Medicare certified room. And then another falsehood and truth. This one, maybe this is the most common one. Essentially, the facility saying Medicaid doesn't pay for this, right? We don't get paid enough by Medicaid. We can't do this, that, or the other thing. We could if you were paying privately. We could if you were paying through Medicare, but we can't do it under Medicaid because Medicaid doesn't pay for it. That is not true. That Medicaid eligible residents must receive equivalent care. Here's the provision from the federal regulations saying that the facility must have identical policies and practices regarding blah, blah, and the provision of services regardless of payment source. So whether it's Medicaid or Medicare or paying out of pocket or third-party long-term care insurance, whatever it is, the facility is obligated to provide the same high level of care. And the standard is under the nursing home reform law, the care that's necessary to get the resident to the highest practicable level of function, right? Regardless of reimbursement source. And you hear facilities saying, well, we can't afford that, and blah, blah, we lose $5.18, for example, every day for a Medicaid resident, whatever it is. As residents and families members, as advocates, we shouldn't put up with that because the facility has agreed to comply with the law that I just mentioned. No one's forcing the nursing facility to certify themselves for Medicaid. They agreed to do it. And when they agreed to do it, they went to the federal government or the state government and promised. It said, yes, thank you for this reimbursement. In return, I will promise to provide equivalent treatment to these Medicaid eligible people. So it's unfair, dishonest for the facilities to make that promise to the federal government and the state government, say, and take the money and then turn around and pick on the most vulnerable person within this transaction, that is the resident, and say, yeah, we took the money, but we're telling you that we don't consider it enough. And so we're not going to do what we're obligated to do. So two falsehoods there, the Medicare bed and Medicaid doesn't pay enough. And I think if you spend much of any time in a nursing facility, you will hear that, and you will oftentimes hear those just presented as the way it is, right? That's how we do business. We're not ashamed of that. We're not hiding it. That is our policy. Then moving on to assisted living. It's the federal law here is, on the nursing facility side, generally the critique is the federal law is pretty good. It just this enforcement is the issue, demonstrated by what I was just saying, that here are these provisions of law. The provisions of law are strong. It's just that the nursing facilities oftentimes aren't in compliance. On the assisted living side, the situation is a little bit different, that the laws aren't very good. It's not just a matter of enforcement. It's about the legal requirements to begin with. So Starting again at the state level, there's licensure. The facilities have to be licensed, and the name will vary from state to state. These may be assisted living facilities or assisted living residences, residential care facilities, adult foster care, home for the aging, housing and services, changes from state to state. And in general, the standards are much looser than they are in a nursing facility as to the level of care that's provided. So oftentimes you'll see state regulatory systems that may define the services that can be provided, right? To say you can need this service or that service or some other service, whatever it may be. You may not be able to walk without assistance. You may be largely limited to the bed. You may need insulin. You may have healing wounds, whatever it is. And there may be a regulatory provision that says you can nonetheless reside in assisted living in our state, but either explicitly or in practice, the state may not require facilities to provide that level of care. And so you see much more variability in the type of facilities. There's arguments against that from the, if you're trying to force a facility to provide a level of care that they're able to do. But I'm just saying in general that regardless, you will see much more variation and variations from facility to facility in the level of care that they actually provide. And sometimes this is informal, that's just what they do. Sometimes it's more formalized in brochures or policies or through the contracts, the admission agreements that they sign with residents may say we will do this and this, but not something else. Now, as opposed to nursing facilities, the federal reimbursement is much less definite. There's not assisted living benefit in Medicaid. So Medicaid has some mandatory services. A Medicaid program has to cover hospital services, for example, physician services, has to cover nursing facility care. And then there are various optional services. This is an option, this is a state option. It's when the state develops its Medicaid program, it has to cover those mandatory services, and then it has the option to cover dental, for example. Some states do, some states don't. Some states, every state really now covers home and community-based services because they've all taken up the option, but they cover it in very different ways. So you don't see assisted living as a mandatory or optional service, but there's no assisted living benefit. So, but there is increasingly Medicaid money in assisted living. So how does that happen? It is generally classified as home and community-based services. So these are the same programs that are used to pay for services in someone's home, for example, right? If I'm living in my home and I need somebody to come in and provide assistance with activities of daily living, cooking or bathing or getting dressed or whatnot, that can be home community-based services. And then Medicaid programs have evolved, if that's the right word, to provide home and community-based services in assisted living facilities as well, to use that mechanism to cover assisted living services. And as an assisted living service, it covers the services, but not the room and board. The same way if in my house, if I get assistance with activities of daily living, Medicaid's not paying for my rent. They're just paying for the services. Same thing if I'm in an assisted living facility, Medicaid may cover the services that are provided, but they're not covering the room and board. That's something that I'm going to have to pay the assisted living facility separately. Now, because of that, and in large part because of that, the quality provisions in Medicaid assisted living are very tenuous. So, because, in large part, because, like I said, the HCBS is not focused necessarily on facility-based care. It was set up to provide services for people in their own homes, and it's just been moved a little bit. It's been used and adapted to cover assisted living, but it's not necessarily set up to deal with it initially. So in the HCBS system, states have to make 6 assurances to the federal government for these HCBS programs. They'll say and they make assurances regarding, tell the federal government, things are okay here. I'm assuring you that we have done what we need to do in regards to these 6 things listed here: administrative authority, level of care, the qualified providers, service planning, health and welfare. And as to assisted living, I'm just going to focus on 2 of these 6 assurances. One is the qualified providers. So the state promises the federal government essentially that the licensure standards are met. You can see those are the 3 inset bullet points here, that the providers meet the licensing and certification standards, right? They're licensed. The state is monitoring them. That's the second bullet point. And then the state verifies that the provider training follows the state law. So mostly just saying, yeah, we've got a state system here. We got a licensing system. We're applying it, but nothing beyond that, nothing specific to Medicaid. And I'll note here, as I failed to note earlier, that the Medicaid population is noteworthy in assisted living by being limited only to those persons who would qualify for nursing facility care. Right? So the state's not going to cover all assisted living residents, only those assisted living residents that have a particularly high level of care. These are people that are able to show, I have care needs that would qualify me for staying in a nursing facility, but I can get Medicaid coverage in lieu of nursing facility care through this program. It's considered a benefit for all concerned, that the state then saves money because assisted living is cheaper than a nursing facility, and the resident benefits by being in a more home-like environment, the assisted living facility, as opposed to the nursing facility. So the state makes its qualified providers assurance. It's mostly just saying that there are licensure standards that are being met. And then there's a health and welfare assurance that, again, that the most relevant sub-provisions are the 4 bullet points I've listed here, that the first 2 really just shows an assurance that the state has some system for paying attention to bad incidents, to critical incidents that take place within the HCBS system. The 3rd bullet is not particularly reassuring, that just the state follows its own policies on restraint and seclusion, and then the state establishes and monitors overall healthcare standards. So largely deferral to the state. You'll note that there are no federal standards here, for example. Again, it's a HCBS program. It's not an assisted living program per se. So in a very dramatic difference from the nursing facility world, the federal government here is not setting really any standards for assisted living, not saying that, for example, that there's a certain level of training that's needed to be a direct care worker, for example, or that a certain level of care has to be provided, or that nurses, or be it registered nurses or licensed nurses, have to be involved in any particular way. There's nothing like that on the federal side. It really is just a deferral to whatever the state system is. The state is required under the federal HCBS regimen to have some performance measures. And the state collects these and reports it back to CMS, and compliance is considered above 85%. So in these waivers, you'll usually see maybe 15 to 20 performance measures, and generally compliance, the percentages that are reported are way above 85%, maybe oftentimes closer to 100%. We had a chance last year, and then in something that was published in the front part of this year, to dig into a particular waiver. We made a public, because this wasn't public, this information wasn't public. Again, in a big dramatic difference from the nursing facility world, where all this information is available online. None of this was available to the public. We had to make a Public Records Act request. California tried to just ghost us essentially, and we ended up filing a lawsuit against them to get the information. So got the information, 18 measures from the California assisted living waiver. Only 5 of them had anything to do with quality. You'll get the link for this report if you want to look at it in more detail, but just note that none of these supposed quality assisted living measures were particularly useful. Like, you can look at these percentage of facilities not allowing licensure to lapse. So that report was 100% or close to it, because they were all licensed through the whole year. All the first 3 are basically all the same thing. I can tell you that all 5 of these generated scores of 100% or virtually 100%, which just indicates the trivial nature essentially of the measures. And these more important questions of what care that's being provided, what's needed. Obviously, if you're familiar with quality metrics in a nursing facility, there's a lot of clinical measures of care that are actually very useful for distinguishing between facilities, but none of that is true here. And important to note that none of this was facility specific. It was all just in relationship to the system as a whole. Recently, for the first time, there has been some regulation that in practice now applies to assisted living. These are the federal HCBS regulations. That the HCBS settings rule was finalized. It was on the books in 2014, but it wasn't fully implemented by the states, supposedly until March of 2023. And the motivations behind this were an intent to make sure that home community-based services were provided in a non-institutional environment. HCBS is designed to create an alternative to nursing facility care. And the critique by some people was, some of these home and communities-based services are being provided in environments that are essentially institutional, right? Daycare centers, for example, where the people never leave their several hundred square foot area. That's not really community-based. Or maybe residential facilities as well, be they assisted living or group homes or adult foster care or whatever. It's not really community-based because people were limited to the facility and there was nothing really non-institutional about them that distinguished them in any meaningful way from nursing facilities. So that's the motivation behind the provisions. And so the provisions include a lot of requirements that are relevant to that. Integration within the community, for example, making sure that people have an opportunity to engage with the community and not be subject to coercion and not be restrained. Then there are also some provisions within those HCBS regulations that are specific to residential facilities. I've just listed a few of them here. Eviction protection is at least as good as what people get under landlord-tenant law in the state. Privacy, including the ability to lock the door to your living unit, again, a feature of non-institutional living. Choice of roommates, a right to accept visitors any time of the day or night. All those are good. They're better than nothing, but they're not focused on residential facilities. And there was a lack of an enforcement mechanism. The state Medicaid agency generally has the capacity to administer these critical incident reports and generate these quality measures. The state licensure agency has more focus on the care provided in the assisted living facility. And they're going to do surveys, for example, periodically. The frequency would vary from state to state, but likely without any kind of jurisdiction over the federal regulations, unless the state made some changes to enable that. So there's a little bit of a mismatch here in the federal promulgation of regulations, but without necessarily a clear mechanism to ensure that they're followed. We have observed, me and some colleagues at Justice and Aging, that despite the 9-year implementation process from 2014 to 2023, there is still some on its face non-compliance. For example, we found at least these 4 states, and there may well be others, where a resident has no real ability to appeal an eviction. I mentioned a slide or two ago that under the regulations, there needs to be eviction protections at least equivalent to what people get under landlord-tenant law. But at least in these 4 states, and like I said, probably others as well, there's no particular evictions. There's no provision that allow a resident to appeal. And we've just started digging into this, there is still a routine use of restraints. The HCBS waiver application just asks states, explain, if you allow restraints, explain how they're used. And it's seemingly to condone use of restraints, but that is in direct conflict with the language of the settings rule, which provides for freedom from coercion and restraint. But what appeared to us to be clear non-compliance. The federal regulations say in HCBS settings, there should be freedom from restraint. A strong statement, freedom from restraint. But if you look at the state laws of in Florida, Oregon, I'm sure many other states, there's provisions that allow for the routine use of restraints in these settings. So in the remaining time, I want to transition to some of these bigger questions. We've just spent 35 minutes or so laying out the framework of the regulatory system in nursing facilities and assisted living, focusing on the federal level. But let's think about the conversations around long-term care facilities and how they play out. First, I note that there is a vulnerable population here, and long-term care facilities are, I would submit, a little bit of a strange thing in society. People aren't, obviously, that families are going to have family members in long-term care facilities, but generally in a sporadic basis. And it's been my experience that residents and families generally enter facilities without a lot of relevant knowledge. They're not thinking, oh yeah, I understand this. I'm familiar with this. I know what the rules are. This is how it works. They're more likely tiptoeing in a little bit, unsure of themselves and what should be happening. And then people identify as residents only for a few years, and they're difficult to organize. So from a coalition organizing basis, it is limited. If you compare it to, for example, persons with disabilities, for example, or folks with diabetes or cancer or heart conditions or whatever it may be, people live with that and they identify and are better able, I would submit, to organize around that and think, I'm living with a disability. For example, the person would say, and I'm 30 years old, and this is part of my reality, and I'm gonna advocate around that, and me and my family members, we're gonna push on that because it's something that's really important. I think that has been harder to do for nursing facility assisted living residents because folks are in general in those facilities for a shorter period of time. Just again, there's not a lot of TV shows and movies or anything about nursing facilities assisted living. People just aren't familiar with it. And then of course, when you're in a nursing facility, you're physically maybe a little bit limited. And so for all those reasons, the organized lobbying is more difficult than it may be for some other populations. And then I submit that the system maybe makes it worse in a variety of ways by assuming that you don't have, as a resident, have anything to say. Here's just an example that the Care Compare website, this is the Medicare website, that there's a nursing home compare function essentially. This existed for a long time now, 20 plus years. And it is focused historically almost exclusively on just finding a facility, right? Here's the federal government has put hundreds of thousands, millions of dollars into developing this website about nursing facilities. And it has been all about just finding a facility. And there are quality measures and star rate. And I'm not saying this is a bad thing, right? Not at all. But I'm just saying there's a discrepancy. There's the exclusive focus on finding a facility emphasizes that there has been almost nothing in this federal site on telling people what the rules are. I'm telling them what they should do when they're actually in the facility. The unstated premise has been you just need to find a good facility. And once you're in a quote unquote good facility, then everything's fine. But that's not how it works. You have to be educated. You have to be prepared to advocate. You have to know what your expectations should be. We put an issue brief out coming up on a year and a half ago, and give CMS some credit. Because of that, maybe because of some other advocacy, they are for the first time going to add some information on those residents' rights. More a legitimate as we haven't seen it yet. So fingers crossed. We'll hope it's relatively decent, but we'll have some more decent information on what people's rights are and what they should look for in a nursing facility after they're in a facility. So, and then this is another issue brief that we did on the same type of topic, again, with the premise of a lot of the nursing facility policy is assuming that residents can't take care of themselves, and they need help, right? But they still make decisions, and there's this language around nursing facilities that always talks about, well, it all has to be person-centered. But the question is, are we taking that seriously, really? Because we should, but maybe we're not. And that's illustrated by the antipsychotic reduction campaigns. There's this partnership to improve dementia care that dates back to around 2014. Maybe you're a little bit earlier. That focused on training for physicians and examining Medicare claims data. How can we find instances of over medication? Maybe we can look at the data and do some referencing and find these potentially problematic circumstances to consider for potential issuance of violations. Again, all that is fine, but what has been ignored in most of that advocacy has been, what about the residents? That the law requires that residents actually consent to medication. So it's not like this antipsychotic administration is happening on the dark side of the moon. There are people there, there are residents there, and their family members there. Why not get to them and enlist their help in saying thumbs up or thumbs down to this antipsychotic medication? Again, just another example where I think the regulatory system has implicitly assumed that folks don't have agency and don't have control to make some decisions. And this doesn't fit quite as well into this discussion, but I need to mention, I think assisted living is harder. Like, as I mentioned, the problems I just talked about on the nursing facility side are a little bit narrower. There's this extensive regulatory system, but the deficit of it has been that there is less recognition of residents and residents' decision making, and maybe an over reliance on the professionals, but without engaging the resident population adequately. That is all true at the assisted living side as well, but then there's some bigger structural problems as well, is that there's not even that initial system, and there's much more of a need on the federal side, at least, to start over on assisted living, not just be limited to this HCBS track, but to take a step back and think about what we want to do to establish federal standards if a significant amount of Medicaid is going into assisted living. So, to conclude, that, and I'm not suggesting that this obviously is going to solve all problems, but it is worth thinking about increasing the residents' voice here, because it's oftentimes not there. You hear in the disability community, folks say nothing about us without us, and it would be a good strategy in the long-term care aging world as well. I mean, I understand that people are at a different point in their lives, and there may be some, you know, differences in some cases of people's ability to participate like that. But that doesn't mean that we shouldn't try, because the absence of trying has led to some ongoing problems. You know, at the facility level, you can see it in how these conversations play out, that facilities present themselves as being all about care and compassion. You know, this is the pastels and the laces and the, you know, we provide compassionate care for your loved one and whatnot. But it's those same facility settings where residents and families tell ombudsman programs, well, I don't, you know, don't say anything. I'm scared of asking for anything. I don't want to be identified as a quote unquote troublemaker. So there's something odd there in that dynamic where residents should feel so so scared, really, of just asking for the care that they're entitled to under legitimate quality of care and under the standards set by state and federal law. And then you also see this this great discrepancy in how you talk about facilities at the public policy level. Facilities frequently paint themselves as the victims, right? These are the people who are punished supposedly by the punitive enforcement system. And, you know, if you do any of these conversations, I'm sure Haley and Richard would be familiar with this, that, you know, the facility saying, you know, we got this citation, we just had a scrap of paper on the floor and, you know, we got a citation. It's so punitive. And it's just all focused on them as the victims of this enforcement system and the surveyor. But there's a reality completely 180 degrees away from that as well, where the facility you know, has an incredible amount of control over what they're doing, a significant level of financial resources for lobbying and for other purposes, and oftentimes these intricate corporate structures that seem designed to hide profits and to, you know, to count as expenses that what are really transfers to each other. That there's been a lot of conversation about culture change in nursing facilities over the years, but it's generally focused on the staff training, right? We're gonna talk to the staff and get them to change the culture. But what's missing there is changing the culture within the resident population as well. That maybe it's the residents that need assistance to be able to implement their rights. Again, not saying that some of these things aren't already happening, but just talking about a degree and a level of focus, taking person-centered care seriously. Care plans are supposed to be person-centered, but in practice they are for not. I know LTCCC does a lot of work on resident and family councils. Again, you know, the Justice and Aging does great work, the Nursing Home 411, Consumer Voice, a lot of us, I'm not saying that these are brand new ideas, but it's just incredibly important and work that's necessary in order to give more energy to some of the other public policy work that's going on. If you have, it's one thing for professionals like myself to go to Congress or CMS and say something, but if there's more of a sense that behind me and behind Richard, behind Haley and other people is a whole group of residents and families who are concerned about these things, it's much more powerful in the arguments that we're able to make. You know, education for residents and family, right? Put them in a better position to have those arguments on a day-to-day basis. You know, maybe good faith arguments or just discussions with facility. I want this, that, and the other thing. You can't necessarily wait for a surveyor to come in once a year or in response to a complaint. You want to be in position to push back in a variety of ways, every day or every week. Enable the enable the ombudsman programs to do some of this work. Stronger enforcement of a lot of what are considered no harm legal violations. If there's violations that just result in a plan of correction, too easy for facilities to just assume no harm, no foul. What difference does it make? Put a little bit of teeth behind that, so a facility thinks twice before violating the law. And like I said, I think, this is the sort of thing that would make a difference. That if you've heard from LTCCC and us and Consumer Voice and others in recent weeks, that there's a effort by the providers to roll back the important CMS minimum staffing standards that just got finalized a few months ago. We want to be able to get more resident voices to Congress and CMS. It shouldn't, right? Those are the people who are obviously affected by this. You don't want their voices drowned out by efforts by nursing facilities to just have all their employees call and complain about the regulations. And then just mention assisted living again. There's more than that's necessary at the assisted living level, but you gotta to invigorate the consumer base. But then when you do that, you need a reset on the federal side, to recognize that the HCBS standards, right, that were designed for care provided in the home just aren't an adequate fit for residential facilities that are providing the equivalent of nurse or providing necessary care for people whose care needs would justify nursing facility care. So, yeah, I appreciate it. I hope this is useful. I understand that it's not, okay, we need to do A and B and then I'll get that C, but I also think it's important every now and then take a step back and think, why are we where we are? What can we do? Sometimes there's a certain sense of running in place in some of this work. And I think we want to think about some of these bigger picture questions in order to recalibrate our work to a certain extent and make it more productive. So it's part of a process. I really appreciate everyone listening today. Thanks to Haley, thanks to Richard, thanks to LTCCC, just to reemphasize the main points that a lot of this policy, if there were more of a sense of residents and their families and just the community saying, we know something about nursing facilities, we're concerned about this, that could be a tremendous help. And I think all of us in the work that we could do, if we keep that in mind, we maybe could make some progress here and there, right? It's all, none of a matter is fixing everything overnight, but it's a matter of making progress every single day, and which is a way that benefits people just individually, and then part of that, this system more broadly. And so with that, I'll turn it over to Haley and we'll go from there.
Thanks so much, Eric. If you could, I'm just going to take over the screen share.
1 second.
No problem. There we go. I'm just going to go through, I just have a couple slides here that I want to mention. So the first one actually is, interestingly enough, it's our last family empowerment program. So these programs really focus on the importance of family councils in advocating for your loved ones. This is our last program from this series, unfortunately, but it should be a really good one. We have Alon Caspi, who has really focused on retaliation over the last several years. He's done a lot of research in this area in different states. So he's going to be our speaker. This program is this Thursday at 12 p.m. These programs are all free, so please feel free to sign up and join us. And this is also, a much more conversational program. So feel free to jump in with, questions or comments on that program. So be sure to sign up for that. And I'll put the link in the chat in just a moment. You can also sign up for our August webinar. I believe it's going to be on August 20th. We're still confirming some details, but make sure to sign up for the webinar just so you get those alerts for when we have all the details finalized. And then just very quickly, you can head to Nursing Home 411 for materials from today's webinar. I will post the video hopefully by the end of today, but maybe tomorrow or Thursday. Again, follow us on Instagram. We just keep that updated with all of our programs and events. And then our Learning Center has a lot of great information too. But I want to just actually hop out of this and get to the Q&A because we have a lot of questions, and I know that we're kind of at the end of time. So I'm just going to mention or get to a few of these questions. Let me just start at the top. And again, I apologize, we're not going to get to all of them just because we're already, close to 2 o'clock here. So I'll just start from the top. So the first question we have is from Richard Moore. He says, as difficult as passing a federal or state law, given the well-funded opposition of the industry, isn't the key that regardless of how strong a law is for consumers, why don't state agencies or even CMS do a better job of oversight and enforcement?
Yes and no. The presentation here would say that all those things are important, but it's not exclusively that. I think part of what I'm saying is that we can't rely on the surveyors exclusively to save us here. I think that ideally there'd be more, greater day-to-day presence in the facilities from residents and others. And so yeah, yes and no. I think sometimes to the extent that the advocacy is focused more heavily on surveyors, I think that it overlooks the other things that we're talking about today that I think are oftentimes a missing piece.
Great, thanks. And the next question is from an anonymous attendee. It says, does any state do its own inspection surveys, or does CMS contract this out in every state?
Well, it's all connected with CMS. It's federal, right? So you're implementing the federal law, so it's always going to be a collaborative process between the state and CMS. Some surveys are done by CMS employees exclusively, but the majority are done by the state people who are working under the federal standards.
Thanks. We have another question from Richard Moore, and this one's a little bit specific about surveyors, but is there a standard for how many facilities one surveyor should be responsible for monitoring? For example, in Massachusetts, there are about 330 SNFs, which is skilled nursing facilities for those of you who are not aware of that little acronym. How many surveyors should the state employ, and what level of experience ought to be expected for each surveyor?
I think the standard is that you need to survey at least annually, and so you need enough surveys in order to do that. There's a protocol. I can't cite you the protocol, but there's a survey team. There's a certain specified number of people in order to do the task as part of the survey, and I can't recall off the top of my head exactly what the experience level is for surveyors. Let me just mention, just jump to a couple of these questions. I think here, how many states use Medicaid for assisted living? I mean, the majority, I don't think it's all of them, but it's close to all of them at this point. But there's a difference in whether there's just a limited number of slots or whether the programs are much broader. So that's maybe more the distinction.
Great, thanks. Did you want to jump to any other specific questions?
Here's a question. In the assisted living setting, does a restriction or restraints also apply to secluded memory care units? So I'll just say that the regulation says freedom from restraints. And then there's some work to be done there about applying that. The problem is that it doesn't appear to have been considered much at all. So, and there's no guidance from CMS. But I'll just say this, it says freedom from restraints. And this is and I think you want to take that, these are supposedly non-institutional settings. And I think we need to take that seriously. I think sometimes in implementation, the reasoning goes, well, we can't do that because we've always done it such and such other way. And this is an opportunity to say, no, we need to live up to what the regulation requires and figure it out, because I know LTCCC has done programs. This is we have as well, that restraints can be overused, and there's people, professionals, who explain why they're not necessary and why there's a lot of non-restraint alternatives that can be used if you put a little more work into doing it rather than reflexively calling for restraints.
Great, thanks. And it's up to you, Eric. I know we are quite a bit over time here, so if you would like to answer a couple others, please feel free. But I just did want to mention one thing. I did put in the chat. It's LTCCC. We put together a guide to nursing home oversight and enforcement. So we looked over all the state agency requirements and kind of narrowed it down into a much more consumer-friendly manual. So feel free to check that out.
No, Haley, I think we've covered a good number of these. Thanks again for the invite. I appreciate speaking here today.
Awesome. Thank you so much, Eric. And thank you everyone for joining us today. Again, the recording will be posted possibly by the end of today, but maybe tomorrow. So be sure to check that out on our website. And thank you again, Eric. Bye all.